Now, I do find it a little bit amazing. You knew in this confirmation hearing you'd get asked about this case.
Yes, Senator.
I find it actually quite remarkable that for this hearing, you still don't even know the three cases the Third Circuit said were critical to resolving the issue of law.
Senator, I reviewed 10 years of work in preparing for this hearing. I don't recall those three cases specifically.
So you didn't have an inkling that you would get questioned and questioned pretty vigorously about a decision with egregious consequences that was unanimously reversed by the Court of Appeals?
Did I have an inkling that I would be questioned about the Spanier case? Yes, Senator, I did.
Senator Ted Cruz turns a Senate confirmation hearing into one of the most morally serious and legally devastating exchanges in recent congressional history, dismantling a Biden judicial nominee over her unanimous reversal in the Graham Spanier habeas corpus case, a case connected directly to the cover-up of Jerry Sandusky's child sex abuse crimes at Pennsylvania State University. Cruz reads the prosecutorial sentencing memo describing Spanier as showing a stunning lack of remorse and as the ultimate decision-maker when it came to reporting Sandusky, then walks through the Third Circuit's unanimous reversal of the nominee's decision line by line, revealing that the appellate court criticized her for failing to examine cited precedents and for failing to mention a third case critical to the legal analysis. The hearing comes to a sudden halt when Cruz asks the nominee to name the three cases the Third Circuit identified as central to the ruling, and she can only name one, despite knowing this case would be scrutinized at her confirmation hearing. Let's dive into the main video.
Thank you, Mr. Chairman. Welcome to each of the nominees. Judge Mihalchik, I want to talk to you about a case you've already discussed considerably, which is the Spanier versus Libby case. That's a case involving Graham Spanier, the former president of Pennsylvania State University, who was investigated, terminated, subsequently criminally charged for his role in covering up the child sex abuse crimes committed by Jerry Sandusky. The sentencing memo written by the prosecutors in that case, state case, noted that Spanier had, quote, shown a stunning lack of remorse of his victims. It further called for him to be punished for, quote, choosing to protect his personal reputation and that of the university instead of the welfare of children. It further highlighted that Spanier, quote, was the ultimate decision maker when it came to reporting Sandusky. Your decision in that case was reversed unanimously by the Third Circuit. Is that correct?
A three-judge panel of the circuit reversed my decision, yes.
Unanimously.
Yes.
The Third Circuit concluded that, quote, under clearly established federal law, state courts have considerable latitude to rule on the meaning of statutes. Yet you construed the rule more narrowly than the state courts to Spanier's benefit. Jerry Sandusky was an evil man, and Spanier, the ultimate decision maker, protected his own reputation at the expense of the children. Why did you deviate in your decision from clearly established federal law, particularly when it had the effect of protecting such a man?
Senator, the crimes of Jerry Sandusky are beyond horrible. They are unspeakable, and as a member of the community and as a mother of two children, they are the worst nightmare for most parents. That was not absent from my mind when I was looking at the case before me. The issue before me was whether the petitioner, who I looked at and treated as I would every habeas petitioner that comes in front of me, received due process in state court. I determined that there had been a violation of his due process rights in the use of the jury instruction that the state court had, and the Third Circuit disagreed with me.
The Third Circuit did more than that. Did the Third Circuit criticize your opinion for not only admitting relevant precedents, but also for not closely analyzing the case law that you did cite?
I can't recall verbatim what the Third Circuit opinion said. As I recall, there were three cases involved in that case in terms of precedent. and I relied more heavily on one of them than the other two.
Do you recall the names of those 3 cases?
I know one was the Bowie case. I can't recall the names of the other two.
Well, here's what the Third Circuit said, quote, "The district court cited Bowie and Rogers but did not examine them closely, nor did it mention Metrish." Now, I do find it a little bit amazing. You knew in this confirmation hearing you'd get asked about this case.
Yes, Senator.
I find it actually quite remarkable that for this hearing, you still don't even know the 3 cases the Third Circuit said were critical to resolving the issue of law.
Senator, I reviewed 10 years of work in preparing for this hearing. I don't recall those 3 cases specifically.
So you didn't have an inkling that you would get questioned and questioned pretty vigorously about a decision with egregious consequences that was unanimously reversed by the Court of Appeals?
Did I have an inkling that I would be questioned about the Spanier case? Yes, Senator, I did.
Let me ask you this. Did then Pennsylvania Attorney General and now Democrat Governor Josh Shapiro praise the Third Circuit's reversal of your opinion?
I don't know what his comments were following the issuance of the opinion.
Well, I will point out that he released a press release, statement by the Attorney General Josh Shapiro on the U.S. Third Court of Appeals ruling reinstating the conviction of Graham Spanier, and you can read that, and he was effusive in his praise. There's a long and unfortunate pattern in this administration of Joe Biden nominating individuals to serve on the bench who have a repeated pattern of showing excessive leniency to criminals, of releasing violent criminals from jail, of releasing murderers from jail, of releasing rapists from jail, of releasing those who committed child sexual assault from jail. I don't believe doing so is in the interest of the American people. I think it is contrary to the views of the constituents of just about every one of ours. But nonetheless, that pattern continues, and the consequences are deeply harmful.
What Ted Cruz did in that hearing room was bring the full weight of preparation and constitutional responsibility to bear on a moment that demanded exactly those things. He did it in the name of children who could not speak for themselves in that chamber. Cruz had read the prosecutorial sentencing memo. He had read the Third Circuit opinion. He knew not just that the reversal was unanimous, but why it was unanimous. And he knew the specific cases the appellate court identified as critical, the cases the nominee herself could not name, despite knowing with absolute certainty that this hearing would scrutinize her record on this exact matter. He had researched Josh Shapiro's public response. He knew that a Democratic prosecutor, a man who later became a Democratic governor, had praised the reversal of this nominee's decision effusively and publicly. That level of preparation is not accidental. It reflects a senator who took his constitutional responsibility seriously enough to actually do the work, to read the documents, to understand the legal framework, and to walk into that room ready to ask questions that could not be deflected with carefully rehearsed answers. And the moral clarity Cruz brought to those questions deserves equal recognition. He named Jerry Sandusky for exactly what he was, an evil man. He named Graham Spanier for exactly what the prosecutors and the appellate court determined him to be, the ultimate decision-maker who chose reputation over children. He did not soften that language. He did not hedge it with diplomatic qualifications designed to make an uncomfortable truth more comfortable for the person sitting across from him. He stated the moral reality of the case plainly and directly, and then he asked the nominee to account for her role in a legal chain connected to that reality. When Cruz identified the broader pattern of Biden judicial nominations showing excessive leniency toward violent criminals, he was not manufacturing a political attack from thin air. He was drawing a documented conclusion from a documented record, and the Spanier case, sitting at the center of that hearing, was not a weak illustration of that conclusion. It was one of the most powerful and morally unambiguous examples available anywhere in the federal judicial record.